Attention if you are over 60. While you are talking during a traffic stop, the police officer is writing down every statement you make, and those notes will be used against you in court if you decide to fight your ticket or if the stop leads to criminal charges. Law enforcement officers will typically record any statements you make during the traffic stop. This includes any admissions you made at the scene. This is why you should say as little as possible during a traffic stop so as not to incriminate yourself. Most people do not realize that officers are trained to document specific types of statements, observations, and behaviors that build a legal case for why they stopped you and what violations they can charge you with. Most police officers write notes often on the back of tickets with details about why you were ticketed and the conditions that warranted the citation. Every apology, every excuse, every explanation you give is being written down and will become permanent evidence that prosecutors can use against you. Today I am going to reveal exactly what police officers write in their notes during traffic stops, why certain statements you think are harmless get documented as admissions of guilt, how these notes are used against you in traffic court and criminal proceedings, and most importantly, what you should and should not say to keep your name out of those incriminating notes. So stay with me until the end because I will also share how to get a copy of the officer's notes and use them to fight your ticket. And if you are watching right now, please hit like so this reaches other people who need this protection, and comment below. Have you ever wondered what the officer was writing while you were talking? Why officer notes destroy your defense? The stakes for what gets written in police notes are enormous because these notes become the official record of what happened during your traffic stop. Most officers will note any admissions made by the driver on pulling him or her over, said she was going 70, asked for a break, sometimes quoting them directly. Here is what most people do not understand. When you go to traffic court weeks or months after your stop, the officer is not going to remember the specific details of your case. They pull over dozens or even hundreds of drivers. But they will have their notes, and those notes will determine what they testify to in court. If the officer's notes don't say much, he probably won't have much to say at trial unless you gave him a reason to remember your specific case. On the other hand, the more detailed his notes, such as a fact-specific statement convincingly laying out what you did, the better he'll probably sound at trial. If the officer wrote down that you said, "I know I was speeding, I am sorry," that note becomes evidence that you admitted to the violation. Even if you later claim you were not actually speeding, the court will believe the officer's written notes over your verbal testimony. An officer typically will not deviate from the notes because they will not remember other details of the incident by the time of the trial and will not want to lose credibility by making a statement of which they are unsure. For seniors, this is especially dangerous because many seniors are raised to be polite and apologetic, which means they naturally say things like "I am sorry, officer," or "it was my fault," without realizing these statements are being documented as legal admissions. Once these admissions are in the officer's notes, fighting the ticket becomes nearly impossible. The court will view your statements as confessions, and you will lose even if you had a legitimate defense. Category number 1: Driver admissions and apologies. The first category of information that officers always write down is any admission or apology you make. This is the most damaging type of statement because it directly proves you committed the violation. Most officers will note any admissions made by the driver on pulling him or her over, said she was going 70, asked for a break, sometimes quoting them directly, "Yes, I ran the stop sign, but my daughter's pet iguana was sick and I had to get her to the vet." Here are examples of common admissions that get written down and destroy your defense. If the officer asks, "Do you know why I pulled you over?" and you say, "Was I speeding?" the officer writes down, "Driver admitted to speeding." Even if speeding was not why the officer pulled you over, you have now given them a confession to use. If you say, "I am sorry, officer," the officer writes down, "Driver apologized for violation," which courts interpret as an admission of guilt. If you say, "I know my taillight is out," or "I forgot to renew my registration," you have just confessed to violations the officer may not have even noticed yet. If you say, "I was running late," or "I was not paying attention," these statements get documented as admissions that you were driving carelessly or recklessly. Of course, you are far better off if there are no such admissions written down. Many seniors make these admissions because they think being honest and apologetic will make the officer more likely to give them a warning instead of a ticket. But this is backwards. Your admissions do not make the officer more sympathetic. They give the officer stronger legal grounds to write you a ticket, and they make it impossible for you to fight that ticket later. The correct approach is to never admit to anything, never apologize, and never explain what you think you did wrong. When the officer asks why they pulled you over, the correct response is, "I am not sure, officer, can you tell me?" This forces the officer to state the reason without getting any admission from you. Category number 2, physical observations and behavior. The second category that officers document in detail is their observations of your physical condition and behavior. Officers are more likely to use force against drivers who appear to be under the influence of alcohol or drugs. These observations are used to build cases for impaired driving, reckless driving, or to justify searches and arrests. Here is what officers write down about your physical state. They document if your eyes are red, bloodshot, or watery. They write if they detect any odor of alcohol, marijuana, or other substances. They note if your speech is slurred, slow, or confused. They record if your hands are shaking or if you appear nervous. They write down if you fumble with your license or have trouble finding your registration. They note if you make any sudden movements or reach for areas they cannot see. The notes should have detailed specific information about road and weather conditions and other nearby vehicles. Here is why this matters. If the officer writes down subject had red watery eyes, spoke slowly, fumbled for license, that becomes evidence for a DUI investigation even if you have not had a drop of alcohol. Red watery eyes could be from allergies. Slow speech could be from medication or just your natural way of speaking. Fumbling for your license could be because you are nervous. But once it is written in the notes, it becomes evidence of impairment. For seniors, this is particularly dangerous because normal age-related changes can be misinterpreted as signs of impairment. Slower reaction time, shaky hands from arthritis, confusion from being stressed by the traffic stop, all of these normal conditions get documented as suspicious behavior. The officer is not writing these observations to be fair or accurate. They are documenting anything that could support additional charges or justify their actions. Category number 3, your destination and activities. The third category that officers always document is information about where you are going, where you came from, and what you have been doing. Pretext stops, stopping for a minor violation to investigate other crimes, are legal under the Supreme Court ruling Wren v. United States. This information is used to develop probable cause for searches or additional investigation. Officers write down your answers to questions like where are you coming from. If you say a bar, restaurant, or social event, they write down subject stated coming from location where alcohol is served. This gives them grounds to investigate for DUI. If you say certain neighborhoods known for drug activity, they write down subject traveling from high crime area. This gives them grounds to search for drugs. If you say you are going to or coming from another city or state, they write down subject traveling long distance with luggage, which is a profile for drug trafficking. Officers document what you were doing. If you mention having dinner with friends, they write down subject admits to social gathering where alcohol likely consumed. If you mention being at a concert or event, they write down subject was at venue known for drug use. If you say you were visiting someone, they ask who and document the name to run background checks. Consent searches where the officer asks permission without a warrant make up over 60% of all searches in some jurisdictions. The purpose of these questions is not friendly conversation. Officers are building a narrative that justifies extending the stop, calling for backup, requesting a drug dog, or conducting a search. Every detail you provide about your activities gets documented and used to support that narrative. The correct approach is to decline to answer these questions. When the officer asks where you are coming from, respond, "I prefer not to answer questions beyond providing my license, registration, and insurance." Category number 4, vehicle contents and items visible. The fourth category that officers document extensively is what they observe inside your vehicle and what you tell them about items you have. These observations and statements are used to justify searches and additional charges. Officers write down everything they see in plain view. Items on your seats, dashboard, floor, or center console. Any weapons or items that could be weapons. Any containers, bags, or packages. Any items that seem out of place or suspicious. Empty alcohol containers, even if they are days old. Anything that could be drug paraphernalia like pipes, rolling papers, or baggies. Prescription bottles, especially if they are not labeled or are in someone else's name. Large amounts of cash visible anywhere in the vehicle. Officers also document what you tell them about items in your car. If they ask, "Do you have any weapons?" and you say, "Yes, I have a pocket knife in the glove box," they write down subject admitted to weapon in vehicle, gave consent to search glove box area. If you explain that you have prescription medications, they write down subject transporting multiple prescription drugs, and they will investigate whether the prescriptions are legal. If you volunteer that you have tools, sports equipment, or other items, officers document these and may interpret them as potential weapons or evidence of criminal activity. Officers often record basic diagrams in their notes outlining an intersection and essential features. This is especially true for red light and stop sign moving violations. Here is the critical point. Once you admit to having anything in your vehicle, you have given the officer permission to look for that item. And while they are looking for the pocket knife you admitted to, they can search anywhere that knife could be hidden, which means they can search your entire vehicle. The notes will say subject consented to search by admitting to having weapons in vehicle. Category number 5, inconsistencies and changed statements. The fifth category that police officers carefully document is any inconsistency in your statements or any time you change your story. If they add new information that isn't included in their notes, you may be able to question their recollection of those statements. These inconsistencies are used to argue that you are lying, which makes you look guilty and gives officers more reason to investigate. Officers write down timeline discrepancies. If you first say you left home at 3 o'clock, but later mention something that does not fit that timeline, they write down subject gave inconsistent timeline, initially stated 3 p.m., later indicated earlier departure. Even small honest mistakes about timing get documented as evidence you are being deceptive. Officers note contradictions in your statements. If you say you are going to the store but your GPS shows a different destination, they write subject lied about destination. If you say you had 1 drink but then mention a different number, they write subject changed story about alcohol consumption, initially said 1 drink, later admitted to 2. Officers document if you correct yourself. If you forget something and then remember it, they write subject failed to disclose item initially, only mentioned weapon after questioning, suggests deceptive behavior. Note whether any statement is a direct quote or an approximation of what you said. Here is why this is so dangerous, especially for seniors. Normal memory lapses, confusion about exact times, or nervousness that makes you forget details are all documented as evidence of dishonesty. If you are honest and trying your best to answer questions accurately, but you make a small mistake because you are stressed or not sure about details, that mistake becomes evidence against you. The solution is to not answer detailed questions in the first place. If you are not sure about a detail, say "I do not recall" rather than guessing and risking an inconsistency being documented. How to get the officer's notes. Now let me tell you exactly how to get a copy of the officer's notes so you can see what was documented about your traffic stop. If you can obtain those notes before your traffic court hearing, you'll be ahead of the game. This process is called discovery, and you have a legal right to see the evidence that will be used against you. First, you must make a formal written request for discovery. A discovery request should list specific documents and evidence in the police agency or prosecutor's possession, such as the police report, and end with a general request for any and all other relevant documents and evidence. The request should specifically ask for all notes, reports, diagrams, and documents related to your traffic stop, the original citation or ticket, any diagrams or photographs taken at the scene, the officer's notes written on the ticket or in separate reports, any calibration certificates for speed detection devices if you were cited for speeding, and any and all other relevant documents and evidence. Second, send this discovery request via certified mail to both the police department that issued the ticket and the local prosecutor's office or traffic court. You will need to send your discovery request via certified mail to the police department that issued the ticket and the local prosecutor or traffic court. Make sure to get proof of mailing so you can prove you made the request. Third, make your request as soon as possible after receiving your ticket. Some jurisdictions have deadlines for discovery requests, and you do not want to miss those deadlines. Fourth, if you do not receive a response within 3 weeks, follow up with another written request. If you get no response to your discovery request within 3 weeks, you will need to go to court and make a pre-trial motion to ask the judge to order the police to provide the information. Many police departments and prosecutors ignore discovery requests because so few people ask for them. Be persistent. Fifth, if your requests continue to be ignored, file a motion with the court asking the judge to order the police to provide the documents. This means that the judge will order the police to give you the information on penalty of dismissing the case. In some cases, if police refuse to provide discovery, the judge will dismiss your case entirely. How to use officer notes to fight your ticket. Once you get the officer's notes, you can use them strategically to fight your ticket. By carefully reading the notes, you can get a good idea of how the officer will testify and what defenses will be appropriate. Here is exactly what to look for and how to use the information. First, look for what the notes do not say. What the notes don't say: if the notes lack key details, you may be able to challenge the officer's memory. If the officer's notes are very brief and lack important details, this means the officer probably will not have much to say at trial and may not even remember your stop clearly. If the notes do not mention which lane you were in, what the weather conditions were, or how close other vehicles were, you can question the officer about these missing details in court. If the notes lack key details, you may be able to challenge the officer's memory. Look to see if the notes mention which lane you were in. Say exactly how the officer recorded your speed if you were cited for speeding. When the officer cannot answer because they did not document it, this creates doubt about whether they actually witnessed the violation. Second, look for inconsistencies between the notes and the citation. If the ticket says one thing but the officer's notes say something different, this is powerful evidence that the officer's recollection is unreliable. Third, check if there are any admissions quoted. Most officers will note any admissions made by the driver on pulling him or her over, sometimes quoting them directly. If the notes quote you as saying something, make sure the quote is accurate. If the officer misquoted you or took your words out of context, you can challenge this in court. Fourth, look for evidence of pretextual stops. If the officer's notes show they pulled you over for one reason but then immediately started investigating for something completely different, your attorney may be able to argue this was an illegal pretextual stop. Fifth, check the diagrams if any. Officers often record basic diagrams in their notes outlining an intersection and essential features. If there is no diagram, or if the diagram is inaccurate or incomplete, you can use this to challenge the officer's version of events. Final advice: silence protects you from bad notes. Let me give you the final and most important advice about what officers write down. The best way to protect yourself from incriminating notes is to say as little as possible during the traffic stop. This is why you should say as little as possible during a traffic stop so as not to incriminate yourself. Every statement you make can and will be documented and used against you. Here is exactly what you should and should not say. Do provide your license, registration, and insurance when asked. This is legally required. Do say good morning officer or good afternoon officer to be polite and respectful. Do not answer the question, do you know why I pulled you over? Instead say, I am not sure officer, can you tell me? Do not admit to any violations. Never say I am sorry, my fault, or I was not paying attention. Do not explain where you are going or where you came from. Say I prefer not to answer questions beyond providing my documents. Do not consent to searches. Say I do not consent to any searches. Do not answer questions about drinking, weapons, or what is in your vehicle beyond what is legally required in your state. Of course, you are far better off if there are no such admissions written down. Remember that the officer is not writing notes to help you. They are documenting evidence to use against you in court. If the officer's notes don't say much, he probably won't have much to say at trial unless you gave him a reason to remember your specific case, a big reason why it's never wise to behave like an idiot when you are pulled over. The less you say, the less they can write down, and the weaker their case becomes. For seniors who were raised to be polite and cooperative with authority, this advice might feel uncomfortable. But understand that being polite does not mean giving up your legal rights. You can be respectful while still protecting yourself by limiting what you say. Finally, if you do receive a ticket and plan to fight it, request the officer's notes through discovery immediately. These notes are powerful evidence that can help you win your case, especially if they show the officer did not document important details or if they contain inconsistencies. Your freedom and your money depend on understanding what gets written down and how to prevent incriminating statements from ending up in those notes.